It appears that we have Judge Russell essentially steering, directing, and controlling this case from its initiation to where we are today. He is, as evidenced in the transcripts, suggesting what the indictment should say, offering to help rewrite the indictment. He is asking to review the discovery.
No, John, I'm going to have to stand up and object. It's going to go into discussion about negotiations. A, I have a right to make negotiations with defendants. B, I have a right to discuss plea agreements with victims. They don't have a right to control it, but they all have, and they have for the last 30 years, been informed about what negotiation offers are. They may not agree with them, but I have a right and an obligation under the law to talk to my victims about what is going to be offered or not offered, about why I think something should be offered or not something offered, and if it's in something that they disagree with, I have a right under the law to talk to them about that.
I'm not attacking the prosecutor, I'm attacking Judge Russell because he's rejecting what he's saying.
Wait a minute, we don't need to attack anybody at the moment. There's an issue, let's talk about the issue. I don't think there's one shred of evidence to support anything to the contrary. And so to the extent that there's an allegation being made by the defense here, the court's explicitly finding there's zero evidence to say that the state in any way engaged in anything they shouldn't have.
So we did not have a right to have private emails about thought process with regards to me and my victims. They have them because they issued a subpoena without notice to me or notice to any one of the prosecuting officers. I have checked my emails and I received no notice.
Those emails are proof of the fact that Judge Russell has and is trying to deny our client of her Sixth Amendment right to a fair trial, 14th Amendment due process rights are being violated. That's the basis of the motion for mistrial and why we're wanting those emails included as a court record on that basis.
I would deny the motion for mistrial on that basis.
We have not been able to examine them in depth. We haven't had time to examine them in depth. And I'm asking for time to do that, or a mistrial if we don't have time to do that.
I think these emails likely constitute the type of evidence contemplated by Morton. I find that particularly given the testimony we had yesterday, they would have been relevant as impeachment evidence. The defense didn't have them. They should have. I don't find any misconduct or intentional act on the part of the state in not disclosing them. Ms. Severn probably didn't even know they existed until she heard from IT just a day or two ago. And IT had up until the point that they were serving that subpoena, had no reason to go look for them. Nobody knew they were out there. Nonetheless, I do think that the appropriate remedy in this case at this point is to grant the defense motion for mistrial, and that's what we're going to do.
And that's without prejudice?
It is without prejudice based on the findings that I've made at this point. Obviously, my guess is some higher court will tell us whether that's right or wrong. I'm also going to issue at this point a protective order for the emails that have been disclosed to the parties. The parties are instructed not to disclose copies of those emails to anyone other than the lawyers involved. They're certainly not, I'm going to put a sealed copy as Court's Exhibit 1, a sealed flash drive in the record so that both sides will have it. If there's any issues that another court needs to look at, it'll be part of the record, but they are not public, they are not to be released, and they're not to go outside of frankly, anybody at the council table right now. If y'all do need a new trial date, we can certainly get you one, and y'all will get in touch with Ms. Vaughn.
The state's requesting a trial date and have it set today.
We have some dates coming up available. We have some cases that we thought were going to go that now we don't think are in the very near future. And so we can get, if y'all will get with them, we can get potential dates worked out. But rather than set a date right now where nobody knows when the witnesses are available, we're happy to give you a quick date. But I don't want to set a date that may or may not be workable based on anyone's schedule and witness issues. But we can get a date quickly.
And Your Honor, I need to thank you for that, because speaking on behalf of my co-counsel and Melinda Terrell and Mr. Bobby Mims, as well as my own self, I am personally aware that every one of us has got a mountain load of trials coming up for very serious cases.
I have sex victims who had to wait for this trial, so I understand that.
There is no victim.
Hang on a minute. I'm going to make it easy on you. I'm going to notify Judge Charles that I'm voluntarily recusing myself, and so I can't set a trial date anyhow. We'll get y'all a new judge and a new opportunity to go forward.
Thank you.
Thank you.